Hello, everyone, and welcome to One Civil Law. So recently, as I'm sure many of you have noticed, Donald Trump has been suggesting various people for cabinet officials and other high officials, other high offices within the government. And there's been some controversy relating to some of these people. And there has been a suggestion that Donald Trump might use the recess power or potentially even the adjournment power to make these nominations happen. And so we're going to discuss the law on that a little bit about what that is and what the president can and can't do. So this would be for any Senate confirmed position. So that would be for all the principal officers and many of the inferior officers as well. So exactly what positions are Senate confirmed and which aren't, we don't have time to get into. But all the cabinet officials and basically the second, third, fourth ranking official usually at the various officials are confirmable by the Senate. So the Senate has to give advice and consent to all these people. I think there's might be as many as 1,000 of them, but don't quote me on that. But the president might have some abilities to appoint people without the Senate. This is a power that has gone non-used in quite some time, to be honest. But we're going to discuss what the law is. And in order to do that, we're going to start with the Supreme Court, because that's always a good place to start. We're starting with the NLRB, National Labor Relations Board versus Noel Canning. The president made an appointment. People challenged the appointment, asked whether it was valid or not. And the Supreme Court said no, and then laid out the groundwork for when the appointments would be valid. So we're going to read through this opinion and discuss what it has to say. This was a 7-2 opinion from the U.S. Supreme Court written by Justice Breyer, who writes the following. Ordinarily, the president must obtain the advice and consent of the Senate before appointing an officer of the United States. But there are some exceptions to that, but yes. But the recess appointment clause creates an exception. It gives the president alone the power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session. So these would expire at the end of the congressional term, which is every 2 years. This session is 2 years long because the House gets reset every 2 years. And so every 2 years is a new Congress, even though, of course, and a third of the Senate also gets replaced every 2 years. So it would be for 2 years, up to 2 years. We here consider three questions about the applications of this clause. The first questions consider the scope of the words recess of the Senate. Does the phrase only refer to an intersession recess, that is a break between formal sessions of Congress? So Congress works for a year and a half and then decides, we're not coming back to the office until our successors are appointed. So they only work for a year and a half, and then they bug off for 6 months until their successors are appointed. That would be an intersession recess. Or does it also include an intra-session recess, such as they're like, we're not going to show up for 3 months in the middle of the summer or whatever. So what recesses count for the purpose of this? The Supreme Court concludes that both kinds apply. So both a break at the end of a session, also a break within a session. Fine. The second question concerns the scope of the words vacancies that may happen. Does the phrase refer only to vacancies that first come into existence during the recess, or does it also include vacancies that arise prior to a recess but continue to exist? So does a vacancy that happens means it has to occur during that time period when the Senate is not there? The Supreme Court says we conclude the clause applies to both types of vacancies, so it doesn't matter when the vacancy occurred. Okay. The third question concerns the calculation of the length of a recess. The president made the appointment here at issue on January the 4th of 2012. At the time, the Senate was in recess, pursuant to a December the 17th, 2011 resolution that provided for a series of brief recesses punctuated by a pro forma session with no business transaction every Tuesday and Friday, that is, say, every fourth day, throughout the term. So every fourth day, they would come in and be like, okay, the Senate is in session, and then immediately be like, we're out of session. So that's a pro forma. It lasts for usually about a minute. In calculating the length of these recesses, are we to ignore these pro forma sessions, thereby treating the series of brief recesses as a single month-long recess? We conclude we cannot ignore the pro forma. So pro forma does actually count, even though the Congress is only there for the purpose of saying we showed up and that we're all going home. The pro forma counts. Our answer to the third question means that when the appointment before us takes place, the appointment in question in this case, The Senate was in the midst of this 3-day recess. So they were, doing the every 4 days thing. And the president tried to make an appointment during the 3-day break. Okay. Supreme Court concludes 3 days is too short a time to bring a recess within the scope of the clause. Thus, we conclude the president lacked power to make the recess appointment. So, yeah, even though the Senate is only showing up every 4th day for the purpose of saying we're here and then goes home again, the 3 days that are in between do not count as a recess that's long enough for the purpose of this exercise. Cool. All right. The case before us arises out of a labor dispute. The National Labor Relations Board found that Pepsi Cola distributor Noel Canning had unlawfully refused to reduce to writing and execute a collective bargaining agreement. It's a labor dispute. There's a labor union. They have a contract. One of the parties isn't playing nice. It happens all the time, right? The National Labor Relations Board, which deals with this kind of thing, comes in, tries to knock some heads together and be like, okay, no, you gotta make an agreement. The board ordered the distributor, which is to say the employer, to execute the agreement and to make the employees whole for any losses. So the NLRB comes in and says, you guys can't play nice. We're going to impose an agreement on you, which is pretty typical. That's one of the things the NLRB does with their time. And you've got to, actually do the thing. Because that's now the agreement that we've imposed on you by law. Fine. The Pepsi Cola distributor subsequently asked the Court of Appeals for the District of Columbia Circuit to set the board's order aside. It claimed that 3 of the 5 members had been invalidly appointed, leaving the board without 3 lawfully appointed members. So the board has to have at least 3 members act, and they're like, you don't have at least 3 members. So therefore, the board can't act. You don't have a quorum. The 3 members in question were Sharon Block, Richard Griffin, and Terrence Flynn. In 2011, the president had nominated each of them to the board. As of January 2012, Flynn's nomination had been pending in the Senate awaiting confirmation for approximately a year. The Senate, of course, is under no particular obligation to confirm anyone on any particular timetable. The nominations of each of the other 2 have been pending for a few weeks. On January the 4th, the president, invoking the recess, appointed all 3. So the president had appointed all 3. The Senate's like, we're not going to vote on them. And the president's like, well, during one of these 3-day breaks, I'm just going to appoint them myself. I'm going to do it myself. I don't need you guys. The distributor argued that the recess appointments did not authorize these appointments. It pointed out the December 17th resolution by the Senate had adopted a resolution providing it would take a series of brief recesses beginning the following day. Pursuant to resolution, the Senate held the pro forma session every Tuesday and Friday, which is to say every 4th day, until it returned for business on January the 23rd of 2012. The president's January 4th appointments were made between the January 3rd and January 6th pro forma. So the Senate met on the 3rd and they met on the 6th. They did not meet on the 4th or the 5th. So he's like, aha, you're in recess. In the distributor's view, each pro forma session terminated the immediately preceding recess. Accordingly, the appointments were made during the 3-day adjournment, which is not long enough to trigger the recess appointment. The Court of Appeals agreed the appointments fell outside the scope of the clause, but the court set forth different reasons. It held that the clause's words, the recess, do not include recesses that occur within a session. Rather, the words only apply to recesses between sessions. So the Court of Appeals says the breaks within a session don't count. They only count if they're at the end of a session, not within a session. That's what the Court of Appeals said. Since the second session began on January 3rd, as they do, the first day is January 2nd, I believe, unless it's on a Sunday, and then it's January 3rd, so January 3rd makes sense. The day before the president's appointments, those appointments occurred during the intra-session recess, and appointment consequently fell outside the scope of the clause. The Court of Appeals added that in any event, the phrases vacancies that may happen during the recess applies only to vacancies that come into existence during the recess. So the Court of Appeals said only vacancies that happen during the recess count, and these vacancies didn't occur during the recess. No one is disputing that. The vacancies that the members Block, Griffin, and Flynn were appointed to had filled had arisen before the beginning of the recess, during which they were appointed. For this reason, they lacked power, and because the board lacked its quorum, the board's order was invalid. We grant the Solicitor General's petition for cert, as they typically do. When the Solicitor General says, hey, would you mind taking a look at this? The Supreme Court typically does. We ask the parties to address not only the Court of Appeals interpretation, but also whether the distributor's initial argument, namely whether the president's recess appointment power may be exercised when the Senate is convening every 3 days. We shall answer all the questions presented, which is nice for a change, Supreme Court. I appreciate that. Like, we're not just going to answer one question and leave you wondering about the other ones. We're actually going to answer all 3 for a change. How nice. We're going to answer all the questions at once. How nice. We recognize that the president has nominated others to fill in the positions once occupied by members Block, Griffin, and Flynn, and the Senate has confirmed these successors. But as the parties recognize, the fact that the board now unquestionably has a quorum does not move the controversy. So the president then appointed some other people. Those people got confirmed. But of course, that doesn't deal with what happened in the past, right? Either the board had power at the time or not. Either Block, Griffin, and Flynn were members at the time or not. Even if they, weren't confirmed, even if other people were confirmed. Maybe they had a seat only for a limited time. That could be a thing. So, there's definitely a quorum now, but that's not the question. And there are pending before us petitions from decisions in other cases, challenges to the appointment of board member Craig Becker. The president appointed Becker during an intra-session recess that is not punctuated by the pro forma session. And the vacancy Becker had filled had come into existence prior to the recess. So not so much with the pro forma in that situation. Other cases involving similar challenges are also pending. Thus, we believe it's important. So the Supreme Court's like, oh, these are really important questions. There's a lot of litigation on this. Maybe we should just solve all the things. Maybe we should just solve all the things and then we won't have to worry about it anymore. And then everyone will know the answer. That's thoughtful. Before turning to the specific question, we shall mention 2 background considerations. First, the Recess Appointments Clause sets forth a subsidiary, not primary method for appointing officers. The immediately preceding clause provides a primary method. It says the president shall nominate and with advice and consent shall appoint people. The Federalist Papers made clear the founding intended this method of appointment, requiring the Senate to be the norm, at least for the principal officers, which is to say the cabinet. Alexander Hamilton wrote in the Constitution that it vests the power of nomination in the president alone because one man of discernment is better fit to analyze and estimate the peculiar qualities adopted to the particular office than a body of men or equal or perhaps even superior discernment. The president gets to nominate people. At the same time, the need to secure Senate approval provides an excellent check upon the spirit of favoritism in the president and would tend to greatly prevent the appointment of unfit characters from state prejudice, from family connection, from personal attachment, or from a view from popularity. So one man gets to make the appointment, but the Senate gets to confirm. Hamilton further explained that the ordinary power of appointment is confided to the president and Senate jointly, and therefore can be only exercised during the Senate, but as it would be improper to oblige the body to be continually in session for the appointment of officers, heaven forbid they work all the time, and as vacancies might happen in their recess, which it might be necessary for the public service to fill without delay, the succeeding clause is evidently intended to authorize the president singly to make temporary appointments. So heaven forbid the House and Senate, actually work every day of the year. They can only work sometimes. And, it would be really unfair to make them work all the time. So, maybe sometimes the president's got to do what the president's got to do. Cool. Thus, the Reset Appointment Clause reflects the tension between, on one hand, the president's continuous need for the assistance of subordinates, and on the other, the Senate's practice, particularly during the Republic's early years, of meeting for a single brief session each year. So they would only meet for a little while and then, bugger off. So the Senate, particularly in early American history, was very, very part-time. They'd only meet for a little while and then bugger off. We seek to interpret the clause as granting the power of the president to make appointments during the recess, but not offering the president the authority to routinely need to avoid Senate confirmation. Secondly, in interpreting the clause, we put significant weight upon historical practice. Fair enough, when you're looking for a constitutional interpretation, text is always great, but history helps. History, intent, procedure, precedent, these are all good things to look at. And so one of the things you can try to look at as a source is, how have we actually been doing this? What has been the understanding in practice? It's like, okay, that's a reasonable way to look at things. For one thing, the interpretive question before us concerns the allocation of power between 2 elected branches of government, namely the executive and the legislative. Long ago, Chief Justice Marshall wrote that a doubtful question, one in which human reason may be paused and the human judgment may be suspended, is the decision of which the great principles of liberty are not concerned, but respective powers of those who are equally the representatives of the people are to be adjusted, because both the President and the Congress represent the people. If not put to rest by the practice of government, ought to receive considerable impression from the practice. So how you guys have actually been dealing with each other will be informative. As we later confirm, the long settled and established practice is a consideration of great weight in proper interpretation. How you guys actually been rolling will be helpfully informative to us. We recognize, of course, that separation of powers can serve to safeguard individual liberty. And that is the duty of the Judicial Department to say what the law is. Marbury versus Madison, hype. But it's equally true the long-standing practice of the government can inform our determination what the law is. Cool. Which incidentally, by the way, extends to a principle of contract as well. Right? This also works for contract interpretation. One of the things that if you have ambiguity in a contract, one of the things you can look at is how the parties have actually been acting. Because, they presumably have been acting in accordance with the contract, right? If everyone's been, operating a certain way for 20 years, and then someone says, well, that's not part of the contract. Well, everyone seemed to think it was for 20 years. So, that goes a long way in contract interpretation too. So that makes sense. The principle is neither new nor controversial. True. As James Madison wrote, it was foreseen at the birth of the Constitution that difficulties and differences of opinion might occasionally arise in expounding terms and phrases necessarily used in such a charter. People might be confused about what the Constitution means. And it might require a regular course of practice to litigate and settle some of them. The Supreme Court might have to step in occasionally. And our cases that constantly confirm this. Yeah, the Constitution needs help. These precedents show that the court has treated practice as an important interpretive factor, even when the nature or longevity of the practice is subject to dispute, and even where the practice began after the founding era. Again, this is one of the interpretive tools, nothing up our sleeves, along with the intent, along with the history, how the text came to be, along with the intent, the practice, the precedent. This all sounds really, really familiar to anyone who's familiar with statutory or constitutional or really any interpretation of law. These are all really good tools. So how you guys been behaving is a valuable tool. Cool. There's a great deal of history to consider here. Presidents have made recess appointments since the beginning. Their frequency suggests that the Senate and President have recognized that recess appointments can be both necessary and appointment. We've not previously interpreted the clause, and when doing so for the first time in more than 200 years, we must hesitate to upset compromises and working arrangements that they've reached. So, no one has bothered asking this question for 200 years. And so, if you've got a good thing going, who are we to step in a little bit? It's like this has been de facto what everyone has been doing. So if de facto, why not de jure? If de facto, why not de jure? If as a matter of fact, why not as a matter of law? Again, nothing up our sleeves here. This is pretty common interpretation. This is a pretty common tool. So we're gonna rely on this tool. Fine. The first question concerns the scope of the phrase "the recess." The Constitution provides for congressional elections every 2 years. It certainly does. And 2-year life of an elected congressperson typically consists of 2 formal 1-year sessions, each separated by an intersession recess. Okay, so fine. So each session is 1 year long, not 2 years long. But it's to the next session. So effectively 2 years, right? It's for until the end of the next session. So each session is 1 year long. Fine. The Senate or the House announces an intersession recess between sessions by including a resolution stating it will adjourn sine die, which is to say we're done now. Right? Sine die says we're done now. This is the end. We're done. That is without specifying a date to return, in which case Congress will reconvene when the next formal session is begun. So sin dine means we're done. Excellent. The Senate and House also takes breaks in the midst of the session. The House or the Senate announces such intra-session recess by adopting a resolution stating it will adjourn to a fixed date a few days or perhaps weeks or months later. All agree that the phrase, the recess of the Senate, covers the intersession recess. The question is whether it includes intra. So everyone agrees that between, sure, but how about within? In our view, the phrase, the recess, includes the within. Cool. So both between sessions and within sessions. Cool. Each words taken literally can refer to both types of recesses. Fair. Founding era dictionaries simply define the recess much as we do today. Simply a period of cessation from usual work. Okay. The founders themselves used the word to refer to intra-session recesses as well as to intersessions. Okay, so the founders used it that term. We recognize that the word the in the recess might suggest the phrase refers to a single break separating a formal session of Congress. That's because the word frequently, but not always, indicates a particular thing. Yeah, so sometimes the doesn't mean the. Sometimes the single is the plural, sometimes the plural is the singular, sometimes should means must, sometimes must means should, sometimes the means a, sometimes a means the, and around we go. And around we go. But the word can also refer to a term used generically or universally. The Constitution, for example, directs the Senate to choose a president pro tem in the absence of the vice president. And the Federalist Papers refer to the chief magistrate of an ancient league who administered the government in the recess of the Senate. Reading the generically in this way, there's no linguistic problem applying the clause's phrase to apply to both kinds of recess. And in fact, the phrase the recess was used to refer to intra-session recesses at the time of the founding, citing some precedent. Cool. The constitutional text is thus ambiguous. Fair enough, I think it is ambiguous. And we believe the clause's purpose demands the broader interpretation. Yeah, it would be a little bit silly if it didn't, to be some sense, right? It'd be a little bit silly if it didn't refer to intra-session. Like if they're like, we're just going to take 6 months off, but we'll be back. It's like, but they're not here right now. So it'd be a little silly if it didn't. So the broader interpretation makes more sense. The clause gives the president the authority to make appointments during the recess of the Senate, so the president can ensure the continued functioning of the government. The Senate is equally away both times. I mean, that much is true. They ain't there. They ain't there. Its capacity to participate in the appointments process has nothing to do. Yeah, the Senate just ain't there, though. So it doesn't really matter either way. History is often offers a strong support for the broader interpretation. We concede that pre-Civil War history is not helpful, but it shows only that Congress generally took long breaks between sessions, while taking no significant intra-session breaks at all. So they took really long breaks between sessions, but didn't take so much within it. Okay. Obviously, if there's no significant intra-session recesses, there will be no intra-session recess appointments. Can't have the appointment without the recess. I mean, that much is fair. In 1867 and 1868, Congress for the first time took substantial non-holiday intra-session breaks, and President Andrew Johnson made dozens of recess appointments. The Federalist Court of Claim upheld those specific appointments, writing, "We have no doubt that the vacancy occurring while the Senate was thus temporarily adjourned during the first session of the 40th Congress was legally filled by the appointment of the president alone." So to the extent there is any precedent, the precedent says this is the way to do it. Similarly, though the 40th Congress impeached the president on charges relating to his appointment power, he was not accused of violating the Constitution by making the appointments. So although they impeached him, they didn't impeach him for that reason. In all, between the founding and the Great Depression, Congress took substantial intra-session breaks in 4 years. And in each of those years, the president made the intra-session appointments. So between the founding and 1930, there were only 4 times that Congress took substantial breaks, and every time the president made the appointments. So we have an unbroken track record. Cool. Since 1929, and particularly since the end of World War II, Congress has shortened its intersession breaks as it's taken longer and more frequent intrasession breaks. So not so much at the end of the term as it is within the term these days. Presidents have correspondingly made more intrasession appointments. Presidents have made thousands of intrasession appointments. President Franklin Roosevelt, for example, commissioned Dwight Eisenhower as permanent major general during an intrasession recess. Badass. President Truman made Dean Aitken Undersecretary of State, and President H.W. Bush reappointed Alan Greenspan as chairman of the Fed. Not surprisingly, the publicly available opinions of the president's legal advisors that we found are nearly unanimous in determining the clause authorizes the appointments. In 1921, for example, the Attorney General advised President Harding that he could make the appointments. The Attorney General reasoned, if the president's power of appointment is to be defeated because the Senate takes adjournment to a specific date, the painful and inevitable result will measurably be to prevent the exercise of governmental function. I cannot bring myself to believe the framers of the Constitution ever intended such a catastrophe. In other words, if the Senate is away and we can't appoint people, the government can't function. That doesn't make any sense. We found memoranda offering similar advice to President Eisenhower and from every president to Carter to the president. And then they cite a whole bunch of precedent for that proposition. We must note one contrary opinion authorized by President Theodore Roosevelt's Attorney General, Philander Knox. Knox advised Philander, nice, what a rough name. Philander Knox, what a rough name. Knox advised the president the clause did not cover a 19-day intra-session recess. But in doing so, he relied heavily upon the use of the word the, a linguistic point that we do not find determinative. And Knox all but confessed that his interpretation ran contrary to the basic purpose of the clause. Moreover, only 3 days before Knox gave his opinion, the Solicitor of Treasury came to the opposite conclusion. We do not think that Knox's isolated opinion can disturb the consensus. So one AG said not so much, but everyone else said yes, and not so much. What about the Senate? Since presidents began making intra-session recesses, individual senators have taken differing views about the proper definition of the recess. But neither the Senate, considered as a body, nor its committees, despite opportunity to express opposition to the practice of intra-session recess appointments, has done so. Rather, to the extent that a Senate or a Senate committee has expressed a view, the view has favored the functional definition of recess, and the functional definition encompasses the intra-session. Most notably, in 1905, the Senate Committee on the Judiciary objected strongly to President Theodore Roosevelt's use of the clause to make more than 160 recess appointments during a fictitious inter-session recess. At noon on December the 7th, 1903, the Senate pro tempore declared a formal extraordinary session of the Senate adjourned without day, that's sin 9, without day, and the next formal session began immediately afterwards. President Roosevelt made over 160 recess appointments during the instantaneous inter-session interval. That's rough, man. That's ballsy. Like, the Senate literally says, okay, we adjourn sin 9, but then because of law, they just come back into session immediately. And it's like, well, you adjourned, you were in recess. So basically in this half a second interval, the president tried to cram 160 nominees through. That's ballsy. That's some bald ass. I mean, we knew TR can ball, baby. We knew President TR can ball, but holy shit. Holy shit. We're adjourned. It's okay. We're going to be back in 30 seconds, though. Well, for 29 of those seconds, I'm in charge. Damn, TR, man, you ballsy. President Roosevelt made 160 appointments. The Judiciary Committee, while stating its strong objection, defined recess in functional terms as the period of time when the Senate is not sitting in regular or extraordinary session as a branch of the Congress, when its members owe no duty of attendance, when the chamber is empty, when because of absence it cannot receive communication from the president or participate as a body. That functioning definition encompassed intra-session as well as intersession. Justice Scalia is right that the 1905 report did not specifically address the distinction between inter and intra, but the animating principle of the report that recess should be practically construed to mean a time when the Senate is unavailable to participate in appointments is inconsistent with the formalistic approach that Justice Scalia endorses. Similarly, in 1941, the Senate helped to enact a law regulating the payment of recess appointments, and the Comptroller General has interpreted that law functionally. And an earlier 1863 statute had denied pay to individuals appointed to fill up vacancies, first arising prior to the beginning of the recess. The Senate Judiciary Committee felt that those vacancies fell outside the clause. In 1940, however, the Senate amended the law to permit many of those recess appointments to be paid. Interpreting the amendments in 1948, the Comptroller General, who, unlike the Attorney General, is an officer of the legislative branch, wrote, "I think it's clear that the Pay Act amendment's primary purpose was to relieve recess appointments of the burden of serving without compensation during its periods when the Senate is not actually sitting and is not available to give advice and consent in respect to the appointments. Irrespective of whether the recess is attributable to final adjournment sine die, we're all going home, or adjournment to a specific date in which we're not. We recognize that the Senate cannot easily register opposition as a body to every governmental action that many, perhaps most, senators oppose. But the Senate has not been silent or passive regarding the meaning of the clause. A Senate committee did register objection to President Theodore Roosevelt's use of the clause, and the Senate as a whole has legislated in an effort to discourage certain kinds of recess appointments. And yet we're not aware of any formal action that's taken to call into question the broad and functional definition of recess first set out in the 1905 report and followed by the executive branch since at least 1921. Nor has Justice Scalia identified any. All the while, the president has made countless recess appointments during the intra-session recess. The upshot is restricting the clause to inter-session recess would frustrate its purpose. I mean, that much I agree. It would frustrate it. Moreover, the president has consistently and frequently interpreted the word recess to apply to intra-session recesses and has acted on that interpretation. The Senate as a body has done nothing to deny the validity of the practice for at least 3/4 of a century, and 3/4 of a century of settled practice is long enough to entitle the practice to a great weight of interpretation. I have no objection to this. In the absence of anything clear, this works for me. The clause is ambiguous. It's unclear what it means. It makes sense pragmatically. The behavior is along those lines, so this makes sense. Not necessarily my favorite tools to use in interpretation, but, we don't really have anything better to work from, so this works for me. We are aware but not persuaded of three arguments to the contrary. First, some argue the founders would likely to have intended the clause to apply only to intersession, for they hardly knew of any other. Indeed, the founding until the Civil War, intersession recesses were the only kind of significant recess. The problem with that argument, however, is it does not fully describe the relevant founding intent. The question is not, did the founders at the time think about intra-session recesses? Perhaps they did not. The question is, did the founders intend to restrict the scope of the clause to the form of congressional recess then prevalent, or they intend the broader scope permitted by the clause to apply when appropriate to somewhat changed circumstances? The founders knew they were writing with a document designed to apply to ever-changing circumstances. After all, the Constitution is intended to endure for ages to come, and it must adapt itself to a future that can only be seen dimly, if at all. We therefore think the framers likely did intend the clause to apply to new circumstances that so clearly fall within the essential purpose, when doing so is consistent with the clause's language. Second, some argue that the intra-session interpretation permits the president to make illogically long recess appointments. A recess appointment made between Congress's annual sessions would permit the president appointee to serve for about a year, until the end of the Senate's next session. But an intra-session appointment at the beginning or middle of the formal session could permit the appointee to serve almost a year and a half or almost 2 years. So if the Senate took a break right at the beginning, if they took a break immediately, then anyone appointed would serve for 2 years, which is a pretty good deal. We agree that intra-session interpretation permits somewhat longer recess appointments, but we do not agree that the consequence is illogical. A president who makes recess appointments will often seek to make a regular appointment, noting the appointment and security ordinary Senate confirmation. And the clause ensures the president and Senate always have to go through at least a full session to make the nomination and confirmation process. That process may take several months. Also, incidentally, of course, you could appoint a Supreme Court justice this way because it's valid for all appointments. I don't know that a Supreme Court justice would want to do this, but you hypothetically could, as you're appointing somebody and then they would serve for 2 years. If Justice Thomas, for example, were to retire or resign, So you could appoint a temp for 2 years. Just saying. A recess appointment lasts somewhat longer than a year will ensure the president the continued assistance of subordinates that the clause permits him to obtain while he and the Senate select a regular appointee. An appointment should last until the Senate has an opportunity to act on the subject, and the clause embodies a determination the full session is needed to select and vet a replacement. Third, the Court of Appeals believed the application of the clause to intra-session recesses would introduce vagueness into the clause that was otherwise clear. One can find the problem of uncertainty, however, either way. In 1867, for example, President Andrew Johnson called a special session of Congress, which took place during the lengthy intra-session recess. Consider the period of time that fell just after the conclusion of the special session. Did the period remain an intra-session recess, or did it become intersession? That's a good point. It's like, when is it intersession? When is it intra-session? It could be actually technically complicated. Or suppose that Congress adjourns sine die, but does so conditionally, so leadership can call the membership back into session when the public interest shall warrant it. If the Senate Majority Leader will to reconvene the Senate, how would we characterize the preceding recess? Is it still intersession? On the narrow interpretation, the label matters. On the broader, it does not. I think that's much fairer. The greater interpretive problem with determining how long the recess must be in order to fit within the clause. So, we've determined that breaks within a session count, breaks outside of a session count, but how long is the break? How long does the break need to be? So that's what we're going to try to say now. Is a break of a week, a day, or an hour too short to be counted as a recess? The clause itself does not say. And Justice Scalia claims the silence itself shows that the framers intended the clause to apply only to the intersession recess. We disagree. For one thing, the likely reason the framers did not place a textual floor underneath the word recess is they did not foresee the need for one. They might have expected the Senate would meet for a single session, lasting at most half a year. And they might not have anticipated that intra-session recesses would become lengthier and more significant than intersession ones. The framers' lack of clairvoyance on that point is not dispositive. Unlike Justice Scalia, we think that most consistent with our constitutional structure to presume the framers would have allowed intra-session recess appointments when there was a long history of the practice. Moreover, the lack of textual floor raises a problem that plagues both interpretations, Justice Scalia's and ours. Today, a brief intra-session recess is just as possible as a brief intersession recess. And although Justice Scalia says the notion the Constitution empowers the president to make unilateral appointments every time the Senate takes a half-hour lunch break is so absurd as to be self-refuting, which, fair enough, he must immediately concede in a footnote. The president can make recess appointments during any break between sessions, no matter how short, which is equally absurd. So you're both suffering from absurdity problems. Even the Solicitor General, arguing for the broader interpretation, acknowledges there is a lower limit applied to that kind of recess. He argues the lower limit should be 3 days, by analogy to the Adjournment Clause, which makes sense to me, incidentally. That makes sense to me. That clause says that neither House nor the session of Congress shall, without consent of the other, adjourn for more than 3 days. We agree with the Solicitor General that 3 days is too short. I'm not sure that's exactly what the Solicitor General said, but okay. The Adjournment Clause reflects the fact that a 3-day break is not a significant interruption of legislative business. As the Solicitor General says, it's constitutionally de minimis. A Senate recess that's so short that does not require the consent of the House is not long enough to trigger the president's recess appointments. That's not to say the president may make recess appointments during any recess that's more than 3 days. The Recess Appointments Clause seeks to permit the executive branch to function smoothly when Congress is unavailable. And though Congress has been taking short breaks for almost 200 years, and there have been many thousands of recess appointments in that time, we've not found a single example of a recess appointment made during the intra-session recess that was shorter than 10 days, not to be confused with that intersession recess, because we talked about that with TR earlier. Nor is the Solicitor General. Indeed, the Office of Legal Counsel once informally advised against making recess appointments during a 6-day intra-session recess. The lack of examples suggests the recess appointment power is not needed in that context. There are few historical examples of recess appointments made during the intra-session recess shorter than 10 days. We've already discussed President TR's appointments during the instantaneous recess, which is pretty baller. President Truman also made recess appointments to the Civil Aeronautics Board during the 3-day intersession recess. President Taft made a few appointments during a 9-day recess following his inauguration. So there's one example, I guess. President Taft did the thing did appointments after he was inaugurated. So I guess we got President Taft for some precedent there for President Trump. President Taft making the appointments right after he got inaugurated. So there's that history. And President Lyndon Johnson made several appointments during an 8-day recess several weeks after assuming office. There may be others to which we're unaware, but when considered against 200 years of settled practice, we regard these few scattered examples as anomalies. Okay. We therefore conclude, in light of historical practice, that the recess of more than 3 days, but less than 10, is presumptively, and notice the word there, presumptively too short. We add the word presumptively to leave open the possibility that some very unusual circumstance, a national catastrophe, for instance, that renders the Senate unavailable but calls for an urgent response, could demand the exercise of a recess appointment power during a short break. In sum, we conclude the phrase, the recess applies to both intercession and intercession if the Senate resource is so short, it does not require the consent of the House, is too short to trigger, and a recess lasting more than 10 days, less than 10 days is presumptively too short as well. So that kind of answers all those questions, and then they discuss whether it applies to recess appointments that occur within or outside of the break, and they conclude it goes both ways. So that is that. Now, there is one other example. There is one other thing that President Trump might be able to do, and no president has ever done it. It would be a first. And that would be to adjourn Congress, during which they would not be meeting. I'm not sure why this is necessary, incidentally, because the Senate could just say, we're taking longer than a 10-day break. Could just say we're taking 11 days. But hypothetically, they could. I'm not sure why you would. Why the Senate wouldn't just say we're taking 11 days, but okay. So in terms of the adjournment clause, the Constitution states that during a congressional session, both chambers of Congress must consent if they want to adjourn Congress for more than 3 days. But the Constitution also says in cases of disagreement between them with respect to the time of adjournment, the president may adjourn them for such time as he thinks proper. So if the House and Senate can't agree, the president can adjourn them. In layperson's times, this would seem to say if the House and Senate disagree on when to adjourn, the president can force it, but it has never been used. So Trump is suggesting that he gets the House of Representatives to propose adjourning Congress. Then if the Senate refuses to do so, he steps in and forces it. So it would be one hell of a thing. And that is something yet to be decided. So that's what's happening there. So the president, so if the Senate takes more than 10 days off, the president can make his appointments to any open position, including judicial appointments, unless, of course, otherwise specified in the adjournment order. And he can get the House to force the adjournment if he wants to. The president can't say stop it with the pro forma because they are meeting. They're not in recess more than 3 days. So he can't stop the pro forma sessions, but he can get the House to force it or the Senate to force it. So that's what that says. So pretty interesting stuff. Now, I don't know whether or not any of that will actually come to pass. It could. Of course, then you would expect it to become common. You know, if the president does it, then you'd expect it to be kind of a feature of every incoming administration, at least when they have either control of the House or the Senate, that you would expect them to force it. But yeah, so that's all the things there. So pretty interesting stuff. So that's the end of the stream. I hope you enjoyed the Supreme Court analysis. I hope you enjoyed that run through. Personally, I don't really think that Matt Gaetz is likely to become the AG. I think he's too controversial. And unfortunately, Trump decided to nominate someone else for Solicitor General, which is very disappointing for me. He nominated one of his own lawyers, la-di-da. So, yeah. Yeah, TR's appointment was interesting. I didn't know about that. Or I'd forgotten about it. I mean, presumably I knew about it at some point because I've read this before, but I'd forgotten about it. So that was interesting reading that. I was like, damn, TR, that's ballsy. Yeah. Well, my friends, I need to take a shower very, very badly. And we'll see what happens next. But until next time, I've been on Civil Law. I hope you're great. Until later, my friends, I hope all's well. Cheers for now, my friends, and goodbye.